Good evening and welcome to the Town of Corte Madera Planning Commission for Tuesday, December 9th. Please get Amy or someone to call the order, please, as soon as you can. So she's going to join by
Commissioner Bandel, Commissioner Rogers, Commissioner Bushoyer, here. Vice Chair Kenny,
Here.
and Chair Chase.
here. Please join me in a salute to the flag. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. So a few little housekeeping announcements for tonight. Amy Lyle, the Director of Planning Development, is going to join us remotely. She'll be on board in a moment. Tonight, we are here specifically to have a public hearing regarding SB 9 and various titles that go with that. So we have a public comment section in the beginning of the meeting, and if you want to comment on any project or anything other than what we're here to do tonight, then that would be the time to make the comment. When it comes to the new hearing, the public hearing, we will take public comment on that alone. The chair will not allow public comment for any other projects related to that, but you can make comments on SB 9 at that point. I hope that's clear. And that goes for everybody online too. So if you're online and you want to make a specific project comment, then in the public comment section that we're about to open here, this would be your opportunity. And in this public comment section, because it's not, any comments are not agendized, staff and there will not likely be any response to those public comments at this time. They will take note of those public comments and they may reach out to you. You may ask for staff to comment to you later, but there will be no response from them regarding things in the public comment section before the new hearing tonight. So with that said, let's go ahead and open up the public comment section for that which is not on tonight's agenda. So you have 3 minutes to make a comment. There will be a timer for it, and you step up to the microphone. And if you're going to speak, make sure you speak into the microphone very well so we can hear you and record you. So any takers on that for, I have one here in the room, so please step up.
Thank you, commissioners. My name is Tucker Hyatt. I live at 47 Alta Way here in the fair town of Corte Madera, and I appreciate having the opportunity to speak. Unfortunately, I planned to ask a question, and I realized that I didn't expect an answer now, but I understand questioning is the wrong format. But I hope it's a sufficiently important question that at least it bears consideration, even if it doesn't deserve an answer this evening. And it's a bit of an essay question, which is not very fair, but I can refine it if you'd like. But I understand response is not part of the program for this initial comment period. I wonder about the effect to which public opinion, to what extent public opinion influences the commission's decisions. I want to offer a hypothetical case of where perhaps a well-meaning, kind Corte Madera family has a plan that is well described and meets all the provisions of laws and regulations in Corte Madera. And it involves public property. In that case, where more than the interests of certainly more than one family are involved, I wonder to what extent the opinions of other families, maybe in the same neighborhood, might be relevant. Or is it really a matter of making sure that all the laws and regulations have been followed rather than an issue of public opinion? There we go. Thanks for considering that. I
Thank you.
believe that public opinion is quite important. After all, we pledged our allegiance to a flag that stands for liberty and justice. And liberty implies that individuals should be able to do what they want on their own private property. But when it comes to public property, I think that justice qualifier kicks in. And there we want public opinion, I think. And the more voices on one side might sway the commission. I hope so anyway. Thank you for listening.
Thank you very much. Anyone else in the room like to stand up to the mic and make a comment on something that is not on tonight's agenda? So is there anyone online, Clara?
No hands are raised online.
So with that said, seeing that there are no takers here, I'm going to say it one more time that you can comment on SB 9 in that section, but not on any specific projects or anything impacted by it. So then we'll go ahead and close this public comment section. So tonight we have a new hearing. This is a review. Public hearing to consider proposed ordinance amendments related to subdivision and developments of qualified Senate Bill 9, so-called SB 9, projects in amending portions of Title 17, which is subdivisions, Title 18, which is zoning, and Title 22, which is objective design and development standards of the Corte Madera Municipal Code. So Martha has written the staff report, and unless anybody else needs to introduce this item, it's all yours.
Good evening, Chair Chase and members of the commission. This evening, you'll be holding a public hearing and considering proposed amendments to the town's existing Senate Bill 9 regulations. A planning staff proposed amendments to the town's existing regulations to comply with a more recent state law, which is Senate Bill 450. The draft also includes several minor clerical and clarifying amendments as well. The draft ordinance is included as Exhibit A to Attachment 1, and changes are shown in strike-through for changes for items proposed to be deleted and underlined for any new proposed text. I'm going to begin the presentation with going over some background information related to Senate Bill 9. Senate Bill 9 was signed by Governor Newsom in September 2021 and became effective on January 1st, 2022. This bill allows homeowners within single-family zoning districts in the state to build up to 2 housing units on their properties or to legally split their lots and then develop each new lot with up to 2 units. Most single-family residential properties in the state were affected by this legislation. It applies to all single-family residential properties within an urbanized area with some limited exceptions, such as if a property has a historical designation. This map is showing the Corte Madera zoning districts, and SB 9 applies to all parcels that are zoned R1, which is the beige color, R1A, which is shown in yellow, R1B, which is shown in a lime color, and R1C, which is shown in green. There are 2 different scenarios for development under Senate Bill 9. The first is additional development when the lot is not being subdivided. So in this case, there could either be a vacant lot in which up to 2 units could be built on that lot. And state law requires that each unit be a minimum that ordinance allows for a minimum of an 800 square foot unit. The next option would be if there's an existing single family home on the property, in which case 1 additional dwelling unit of 800 square feet could be built. And in Corte Madera, we have not seen a lot of the latter where there's an existing home and someone proposes to build an 800 square foot unit. And that's because most people are using ADU law to build an additional unit on their property. The second option would be for a property to be subdivided into approximately 2 equal sized parcels. Following the lot split, each parcel is required to be a minimum size of 1,200 square feet. And a homeowner could build up to 2 units on each of the 2 lots for a total of 4 units. More recently, Senate Bill 450 was signed by the governor in September 2024, and this bill became effective on January 1st, 2025. The bill amends Senate Bill 9 in several ways, which is noted on this slide. And most notably, the bill prohibits local agencies from imposing any objective zoning, subdivision, or design standards that are not applied uniformly to all parcels within the underlying zone. Development standards that are applied to SB 9 developments can be more permissive than standards that apply to the underlying zoning district, but they cannot be more restrictive. So staff is proposing several amendments to the existing ordinance to comply with this new state law. So next slide. So as mentioned, the legislation was signed in September 2021 and became effective on January 1st, 2022. So given the limited amount of time between the ordinance was signed and became effective, the town council adopted an urgency ordinance in early 2022 to regulate projects submitted under Senate Bill 9. The urgency ordinance that was adopted by the town council established a ministerial review process and also included objective standards that would apply to the development and lot splits of these types of projects. And subsequently, in December of 2022, the town council adopted the permanent regulations for Senate Bill 9 projects. And these regulations have been in effect since that time. The permanent SB 9 ordinance that was adopted in December 2022 included amendments to Title 17, which is subdivisions, Title 18, which is zoning, and Title 22, which is the objective design and development standards. The ministerial review process that was included in the permanent ordinance was the same as what was included in the urgency ordinance, except for the ministerial process for the lot splits was moved from Title 17 into Title 18. Most of the objective standards that were included in the permanent ordinance were also included in the urgency ordinance as well. And staff believes that most of the existing objective standards that are in the SB 9 ordinance can continue to apply to these types of projects. Okay, so in Corte Madera, since this bill became effective on January 1st, 2022, the Planning Division has received applications for 11 Senate Bill 9 lot splits as shown on this table. And this table was also included in the staff report as well. I know the text is hard to read on the slide. Consistent with state law, these applications have been reviewed ministerially for compliance with the standards in the town's both urgency and permanent ordinances. Of these 11 applications, 8 of the maps have been recorded. And to date, we have not received or approved an application for a 2-unit development on any of these parcels. However, the property at 208 Chapman Drive, that property owner submitted a design review application to construct an approximately 1,800 square foot unit, and the Planning Commission approved that project last year, and it's currently under construction. This map is showing the location of the SB 9 lot splits that have been submitted in Corte Madera. This was included as attachment 8 to your staff report. And most of the applications that have been submitted are in the hillside areas of Corte Madera. That's likely because these tend to be the larger properties in Corte Madera. None of the applications are located in a flood zone, and all of the 11 applications are within the wildland urban interface area. The town council also previously adopted an ordinance that established objective design and development standards for qualifying multifamily projects. And these standards are included in Title 22, which is the objective design and development standards. And the odds toolkit includes different zones. And one of the zones that was created is the T3 edge zone. And this zone applies to development projects submitted under Senate Bill 9. So this slide is comparing the R1 zoning district standards to the T3 edge zone standards. And you can see the standards are very similar. The only current difference is that in the T3 edge zone, there is a height standard to the eave and the parapet of 22 feet. And the interior side setback is also slightly different. So in order to comply with Senate Bill 450, staff proposes to amend these two standards to match the R1 standards. So the town's existing SB 9 ordinance includes different size and height requirements for units. And this was based on if the unit was reducing the setbacks of the property as is currently allowed by SB 9. So the next few slides include some information on the existing size and height requirements. So the urgency ordinance adopted in January 2022 established a maximum unit size of 1,000 square feet. The permanent ordinance adopted in December 2022 included a two-tiered approach to size. This limited unit size to 800 square feet if the unit reduced side or rear setbacks beyond the applicable standards of the T3 edge zone. And state law allows for an SB 9 unit to reduce setbacks to 4 feet for side and rear. The allowable unit size was up to 1,200 square feet when the proposed unit met the required setbacks of the T3 edge zone. Staff felt that the increased size could function as an incentive to encourage property owners to comply with the T3 edge setbacks instead of reducing them as allowed. And if a homeowner wanted to build a unit larger than 1,200 square feet, then they would submit a design review application, as was the case with the homeowner of 208 Chapman. And to preserve the town's existing 1,200 cap on SB 9 units while complying with Senate Bill 450, the design review chapter is being amended to exempt new units that are 1,200 or square feet or less from design review requirements. The existing T3 neighborhood zone currently includes a height requirement of 22 feet to the highest eave parapet and 30 feet overall. The height standard to the eave and parapet is inconsistent with Senate Bill 450, since the underlying residential zoning districts do not have that type of height standard, but rather they establish a maximum height standard of 30 feet. So the draft ordinance removes the height standard to the eave parapet and leaves in place the maximum height standard of 30 feet. The permanent ordinance that was adopted in December 2022 included two different height standards. The allowable height is the same as the height in the T3 edge when the project meets the setbacks of the underlying zone. And the maximum height for units that reduce the setback to 4 feet for side and rear as allowed by Senate Bill 9 have a maximum height of 16 feet. And in addition, the ordinance included an allowance for an increased height of up to 20 feet if the unit was located in the floodplain and the unit was being raised to comply with FEMA regulations. And I'll go over, I have some visual examples of this because I know that's a lot of information and a bit confusing. So the first scenario is shows the height of an SB 9 unit that is meeting the setback requirements of the T3 edge zone, which again mirror the setback requirements of the R1 zoning district. So in this example, the unit meets these setbacks. The maximum size of the unit is 1,200 square feet. The maximum height is 30 feet, and the proposed ordinance removes the maximum height requirement of 22 feet to the eave and parapet to comply with Senate Bill 450. The setbacks of the front would continue to be 20 feet. The interior side setback would be modified to 6 feet to comply with Senate Bill 450. And then the rear setback requirement is 25 feet. In this next example, the property is not in the floodplain, and the setbacks are being reduced to 4 feet for the side and rear, as is allowed by Senate Bill 9. So in this case, the maximum unit size is 800 square feet, and the maximum height of the unit is 16 feet. And the setbacks for the side and rear can be reduced to 4 feet. In this last example, this is showing a property that is in the floodplain, and the structure is being raised 4 feet to comply with both FEMA and Corte Madera regulations. So the maximum unit size is still 800 square feet, and the maximum height is 20 feet. So that is a 4-foot increase, and it assumes that the structure is being raised 4 feet to comply with FEMA regulations. And in instances when the height is increased because it's being raised, the side and rear setbacks are increased, and the increase is 1 foot for every foot of height that is being modified. So in this case, if it's a 20-foot tall structure, there's an additional 4 feet requirement for the side and rear. So the setback is 8 feet instead of 4 feet. The adopted ordinance included several objective standards related to fire access, which are shown on this slide. Planning staff discussed these requirements with the Central Marin Fire Department with the Fire Chief Martin. And Fire Chief Martin confirmed that all of these standards are required of any new unit in the wildland urban interface. And so no changes are required to these existing standards. The adopted ordinance also included several objective standards related to fire suppression, as shown on this slide. And one of the existing fire suppression standards requires that when a unit is located 5 feet to a fence, the material of the fence be a non-combustible material. And this standard is not applied to new units in Corte Madera. And as such, the draft ordinance removes this requirement in order to comply with Senate Bill 450. So the draft ordinance includes some additional amendments to Title 17, which is the subdivision title, and also proposes a new section in Title 18 related to protected unit. The revision to Section 1721.130 modifies the timeframe in which someone can parcel map. And this change is being made to ensure consistency with the Subdivision Map Act. And the change to Section 1721.040, this is modifying the process that's in the code for processing a map. And the current language is very outdated, and it doesn't match current processes of what is actually done. And the new section in Title 18 is Section 1824.115. And this, again, is in response to the Housing Crisis Act. And among other things, the Housing Crisis Act precludes the town from allowing the removal of units on a property. And it also includes a definition of protected units. So the new section is adding some additional information to comply with the Housing Crisis Act. I'm now going to turn things over to Anne. There was a revised draft ordinance that was published today that was provided to the commissioners and also posted online and sent to the interested parties list. And the revised draft ordinance includes 2 new definitions. And Anne is going to speak more about that.
Thank you, Martha. This is a clarification of what we believe would have been the original intent when our ordinance was originally adopted. There's a reference to requiring right-of-way later on in the definitions. Right-of-way was not defined. Later on in the ordinance, there's a requirement that each parcel have access to a right of way. We want to clarify by this definition that it can't be a pedestrian right of way. It can't be a bike path. It has to be something that's improved for vehicular access if the applicant is proposing to use it for vehicular access. Similarly, we wanted to provide that street, another term that's used, the ordinance requires frontage on a street. That a street means an improved street, not a passage or a trail or path that only exists on paper, but has never been improved to be an actual street. So there's one correlating amendment in 040 section, I think it's B11, yes, B11, where we clarify that it has to be that the parcels must have access to a public vehicular right of way. And again, not just a pedestrian path or bike path. So if there are no other questions, that's the extent of it.
All right, we're going to ask you questions from the dais up here. So does that conclude what staff is going to tell us?
That includes the last slide, just shows the options available to the Planning Commission this evening. So a draft resolution was prepared for the commission to consider, and then the draft ordinance, which shows the proposed modifications to the existing SB9 regulations. Alternatively, the commission could provide direction to staff about further revisions or provide direction for staff to return with more information. So that concludes our presentation. And again, Amy Lyle, the Community Development Director, is participating via Zoom and available to answer questions as well.
Great, thank you. So we'll start out the next phase of this meeting by asking the commissioners for their questions of staff. And then we'll go to public comment after that on this item. So I'm going to start over on my right and all the way over there to Valerie and see what she's got for staff.
All right, I have a few questions. Okay, so just as a clarification, today we are voting to propose to submit these revisions to the town council. It's not necessarily to revise the objective standards or propose the objective standards, correct?
Yeah, so you're considering the draft ordinance that's been prepared, and ultimately the town council's the decision maker on the amendments to the SB9 regulations. So the commission would be making a recommendation, and there'd be future hearing at the town council. So we're really focused on our existing SB9 regulations and modifying those to comply with state law.
And these particular amendments will be effective from the time when the town council accepts them, or they will be affecting from January 1st?
Yes. So the town council, it takes two meetings for an ordinance to be adopted. And then there's 30-day effective date once the council adopts an ordinance. So the soonest would be, towards the beginning of March.
Okay, so all of the projects that were submitted prior to March will comply under the older ordinance, correct?
Correct.
Okay, thank you. All right, so then I have a bunch of questions that I had prepared here. When you are saying that the local agencies must consider an eligible project with discretionary review or public hearing, does that apply only to the lot split, or would that be applicable to the project that would be built on a lot split?
So both the lot split and a 2-unit development application are required to be reviewed ministerially. For any 2-unit development, there are objective design standards in Title 22 that would be used to evaluate the project. So some of the attachments to the staff report are information on the existing development standards related to both development standards for things such as setbacks, and there's also design requirements as well, which were included, I believe, as attachment 9.
Mm-hmm. Yeah. So then if someone is applying for the lot split together with a project as a one single family house, would that go to the design review, or would that be considered as part of this split SB9?
So if someone was proposing a unit that exceeded 1,200 square feet, then that would require a design review.
Understood. Okay, thank you. And then there is a note that is saying that 25% of the existing exterior structure was removed. Would that be then considered as a new construction? If people will be renovating their properties to meet or to align with the lot split, would that be considered a new construction?
Yeah, so the original statute included a limitation that only a maximum of 25% of a unit could be demolished. And that really pertains to when there was a tenant that resided in the unit within the last 3 years. So that often generally didn't come into play regardless, because for the most part, it's homeowners that are making, submitting applications. That's typically what we've seen. But yeah, so if someone came in now, they potentially could demolish an existing unit and then submit an SB9 unit.
And this is just a clarification to the previous conversation. And that when the lot is split, there is a potential that duplexes could be built on each lot, meaning that 4 lots and 4 units in total, correct?
Correct. So yeah, someone could first do a lot split and then propose up to 2 units on each lot.
Got it. All right. And then there is a timeline question that I had. So it's saying that if the project is not approved or denied within 60 days, then it's deemed to be approved. Is that enough time for staff to turn this around, or how will that work?
So that time frame starts once an application is complete. So the process is, an application submitted by the town, it's reviewed, and then comments are provided to the applicant. The application's revised, and then once it's deemed complete, then at that point the town sends out a courtesy notice to the neighbors when there's a 10-day comment period. And then once a decision is rendered, there's also a 10-day period in which someone can request a review of the record. So in order to meet that 60-day timeline that's in state law, the ordinance requires a decision to be made within 40 days of the application being complete. And that's so that we can still fit in those 10-day timeframes for a note for someone to request a review of the record and still meet this state law. It is a rush time frame.
Understood. And then there is a potential if there is a public opinion that would come and deny or will try to appeal the decision. Basically, the project cannot be appealed, it sounds like, because it will not fit into this timeline.
It's not an appeal per se, but the current ordinance and also the ordinance before the commission's consideration includes what we call a review of the record. So a member of the public could file a review of the record, and then the decision maker is the town manager, and the town manager is going through the record to verify that the ordinance was appropriately applied and that staff was correct in whatever determination they made with the application. So it's still not a discretionary review, but it does create an additional layer of review.
Understood. Okay, thank you. All right, and then just a small note where on page 3, where you're saying the planning division has received an applications for 11 SB9 lots, but then you're saying the town has not yet received an application for a development project submitted pursuant to SB9. I know you mean the 2-unit projects, so perhaps their clarification in the language would help to avoid the confusion. And then I have a question on the table for the project addresses. So 1161, it has been split, but it doesn't seem to meet the minimum. The minimum is 1,200, and they want to use a 60-40 rule of equal size, and it doesn't seem like that one is meeting the requirement.
So the 60-40?
60-40 rule, yes, that was stated on page 1, approximately equal size 60-40 split. And then it's saying that 1,200 square feet minimum for the parcel, and then 1161 is less than the 1,200.
So 11.
Oh, sorry, that's acres. Never
Acres.
mind. That's my mistake. I totally missed because everything is a SF and I'm just like, what? Okay, never mind. Thank you. Okay. And then the other question is if the homeowner is trying to split the lot that is currently under or classified as a deed restrictive project. Now you mentioned briefly about it. Would that be allowed? Or what procedures would have to go in terms of meeting the state requirements?
So if there's an existing unit that's been occupied by a tenant, is that the
If
question?
there is an existing unit occupied by a tenant, or if it's, an affordable housing unit or any of those.
It can't be demolished if there's been a tenant within the last 3 years. So the state's trying to prevent a situation where there's existing housing units and someone comes in and demolishes the units and build new units and displaces tenants. So there's this requirement that if there's been a tenant, you can't demolish any units.
So they can submit an application to split the lot, but not to proceed with the projects?
Well, you would have the same problem because if the subdivision, it all contemplates 2 new units on each new parcel, then by implication, you're destroying the existing unit. You could represent, or perhaps as a condition of approval, we could require that they undertake not to demolish the existing rental unit. But I think it would be considered ineligible under the terms of SB 9.
I see. So in that particular case, the state requirements for the deed restrictive or tenant property, that would take priority over the SB 9.
Well, there are actually 3 conditions under which it's not eligible for SB 9. One of them is the deed restriction. But if it's been rented even without the deed restriction, or if it's been subject to rent control, it still can't be demolished. And moreover, the Housing Accountability Act also protects those units and for a longer period of time.
I see. Okay, thank you.
Fair amount of state law protection for existing rent.
Understood. All right. And then on page 5 on the table, just a quick note here, it would be helpful to put all of the SB 9 footnotes that you have here in a separate column, because you have the column for R1 and then T3 Edge. And it would be nice to have a column for SB 9 just because it's confusing, because all of the notes are kind of related to all 3 in a way. So it's difficult to read those.
The SB 9 units required to meet the setbacks of the T3 zone.
I see. Okay. Okay. Now it makes it a little bit more clear. And then and actually in your presentation, you had a good diagram for when you were showing the heights with the reduced setbacks. If you don't mind going back to that, because I think it's perfectly illustrating the question that I have.
Is this in floodplain or in the regular?
In a regular, yes. I think slide 19, perhaps. Yeah, this is the perfect one. So here you're actually diagramming the 4-foot and then 90-degree 4-foot for the side and rear setbacks. How would that comply with the ADA turning radius of 5 foot if someone needs to meet that? Because you don't have a turning radius basically there in the corner. So when the setbacks and rear backs are 4 foot only, meeting at 90 degrees, that doesn't comply with ADA standards.
Sure, considered that. These are the same setback standards for ADUs as well. So oftentimes there's conflicts in state law.
Okay.
That's one of them.
Okay. Oh, and then the question on page 7, where you're saying that if the project is larger than 1,200 square foot, then it will go under the design review and to the planning commission. But how would that be different if the homeowner decides to develop the lot under the housing element law. So if someone decides that it will be an affordable housing unit on one of their, like half of the lot, how would that be applicable?
So there aren't affordability requirements for SB9 developments. There could be a case where there's an existing unit that has deed restriction. Typically, for the most part, at least in Corte Madera, the majority of affordable units are in multifamily structures. We don't typically see them in single-family zoning districts. So it's nothing that's ever.
Well, my question is more related to the future. So if the developer buys a lot and decides to split it and decides to build 4 units under the Affordable Act, how would the design review would be applied to that particular case?
So the town's inclusionary ordinance does not require on-site units for projects less than 5. So if someone did a duplex on each lot and there were 4 units, they would have to pay an in lieu fee, but there's no requirement to actually have an affordable housing unit.
But they could go that route.
They could opt to, yes.
Okay. Understood. Thank you. All right. And then for all of the parts for the Title 17 and Title 22, is the environmental impact, all of these exemptions, all of the titles are covered under the exemptions because it's of the state law?
Correct.
I see. Okay. I have just a few, but I can leave it for later. That's fine. Thank you.
Okay, all right.
It took a
Well,
lot of time.
good, then we can move on to Dan over here and hear what he has to ask staff at this point. Yeah.
Okay. I'm still a little unclear on the timing. I see places where it's 30 days, 40 days, and 60 days. I understand the 30 days staff has to decide whether the submission is complete. What happens, let me go on. And then there's 40 days, and then a decision has to be made in 60 days. Otherwise, the plan automatically gets approved.
Well, we were I should say reverse engineering our timeline. The state's law says 60 days. And if you don't approve or deny in 60 days, it's deemed approved. If you do deny within that time period, within that 60 days, you also have to provide an explanation of the various deficiencies of the application. So again, 60 days. We talked about whether or not the process for review of the record could potentially make it impossible to meet those 60 days because it has the 10 days here and the 10 days there. And we decided that in an abundance of caution, we would shorten some of the time periods for decision so that there would be that extra 20 days for review of the record and making a decision. So the only, the alternative would be to just eliminate the review of the record process. But we thought that the Planning Commission would prefer this route.
Okay, and the 30 days we have to decide whether the application is complete or not. What if you decide at 30 days it's still not complete?
Well, the letter goes out saying this is what's wrong with your application. And then they have, I think, their leisure to complete that application, and then our clock starts over again.
Okay. Let's see. What sort of timeline are we under to move this forward to the town council?
Well, SB 450 has been in effect for almost this entire year. So if the commission needed additional information or wanted to see additional changes, then this hearing would be continued to a future meeting. So there's not an immediate rush that this gets done. This is something that's been on staff's work plan. And we don't want to delay too much because we do want to be consistent with state law, but there is the ability for the the commission to pause if more information is needed for you to make your decision.
So while Dan's looking, okay, no, I just wanted to chime in on that, but go ahead,
Go ahead,
please.
go ahead.
No, so if it's not conforming to SB 9 or 450, then what's the implication for not having this in comporting with those two legislative elements?
Fortunately, it does not appear to be as draconian as in the ADU context where the entire ordinance is void. We still have our ordinance, but there are parts of it that we can't enforce. And I think it's best practices to have what's on the books match what you can actually do. It's better for staff, it's better for the public. But that being said, we would typically have to refrain from enforcing some components of our ordinance. That can give rise to confusion, but hopefully it would just be for a little while.
Yeah, does that help, Dan?
That's fine.
Okay.
But I still have one more question.
Of course, yes. Right.
So what's the relationship between someone submitting to do a lot split and any submission of actual plans for roads, driveways, homes? In other words, you could do the lot split, you have a record lot now, extra record lot now. How long can you sit on that lot? And can you submit and get the lot split? Is there a time frame within which you have to submit?
No, but to go back to the earlier part of your statement, it's pretty clear from both the state law and the intent of our own ordinance that there was presumptively going to be a street by which the two parcels could be accessed. So that would be a hitch. That would, I think, be something we would have to call out completeness and say we can't apply. There's no way to get to or from the new parcel. But no, they don't have any deadline to submit their 2-unit application. And they could change their minds and decide they wanted to build 1 unit. That would be an option for them too.
Okay, that's it for now.
So the fact is that a homeowner can split the lots, anybody can split the lots and then sit on it for as long as they want before they do any development plan, once the approval is completed. Right. Then that lot does not require any development for them to sell or do anything else with that lot.
That's correct.
The lot split applications that are submitted does show anticipated location of new structures because there are a variety of requirements that they need to comply with related to distance of, fire hydrant needs to be within 350 feet. So that's required so that the staff can evaluate if a application would meet those development standards. And it's also good that a homeowner knows what the requirements would be so that they can understand if it's even financially feasible.
So that brings me to a follow-up question then. For example, your statement about distance to a fire hydrant, they could draw a circle on the plan and show that the future house will be within the circle and therefore within approved distance to a fire hydrant. They wouldn't actually have to show a house footprint.
They show the maps typically show a house footprint and then any driveway locations and then any parking areas. And then they would show the distance of the anticipated house locations to fire hydrants.
So essentially you're saying that would be required.
That is required. That is something that's submitted as part of a map application, but they don't need construction level drawings. It's more, a site plan.
Okay, thanks.
Okay. All right. Margaret, over there.
I think we need a list of what exactly the planning commission is allowed to do. It's kind of mixed up in there. But my question is, and I don't exactly know how to say it, but like last week or the last meeting, we looked at a project where the applicant had a building that was non-conforming to present day standards. So if somebody wanted to develop an SB 9 project, how would that work with the fact that you have houses that are non-conforming to present day standards, but these standards have to be enforced on the SB 9 under that auspice? How would that work?
Provide that they can have reduced setbacks if there's an existing structure. So they could replace that existing structure with a new unit or just use it for, it's one of the units. But if they wanted to, but they couldn't expand on that nonconformity. They couldn't increase it. And we wouldn't be able to require them to eliminate it either. To your earlier point, when it comes to SB 9, your input is here at the policymaking stage of the planning commissions. These projects themselves will never get to the planning commission. So you won't see them unless you're interested enough to monitor the applications that come in.
Right, so a building would just go up without anybody really had knowledge of it.
Well, there will be an application and staff will send out the notices that are specified in the ordinance, but there wouldn't be any public hearing. That's expressed in the state law that there can't be a public hearing, that it has to be done at a ministerial level.
And you expressed some concern of an issue that wasn't really dealt with in the package that we got. You want to talk about that?
I think it has to do with an issue that's still under consideration, and so I'd rather not talk about it at this point, if you don't mind.
Okay.
Okay. Thank you. On to you, Andrew.
Thank you, Peter. I just have a few questions. For projects that have already been submitted, such as on the list there, my understanding is that the new ordinance, if anything, is more lenient, not more restrictive. Is it possible that any of those projects could benefit from the new ordinance, or they strictly have to adhere to the previous SB 9 ordinance?
So for instance, if a 2-unit development was being proposed, the requirement, the height requirement, the 22 feet would not apply because that's inconsistent with state law. So there are parts of our existing ordinance that do not comply with state law. So an application could potentially benefit.
Okay, got it. The courtesy neighborhood notice, what's the radius on that? Or is it just on a case-by-case basis when you determine who has to be noticed as part of that?
So we do a 300-foot notice.
Okay. Okay. And then for a lot split, you create a new lot, you have the option of creating 4 new units if none exist. If there's a newly created lot and you can do 2 units, do you still have to have a primary unit and a secondary unit, or can you do 2 primary units?
Would be if you were developing under SB 9 and you were doing 2, equal size 1,200 square foot units, we would consider that, likely you would need one to be a primary and one to not be a primary. That really only comes into play when someone's doing an ADU, because the accessory dwelling unit needs to be accessory to a main house.
Got it. Got it. But they both cap out at 1,200 square feet. And then finally, as far as access goes, in other words, there's a lot of streets, obviously, in Corte Madera that aren't 20 feet wide. So if you have to widen a street, does that work need to actually happen before you can apply for a building permit for the units? Or do you just have to have an approval for that work?
In fact, you cannot, in most cases, require an SB 9 applicant to construct off-site improvements.
Including the widening of a street?
Yes, they cannot be required to do that. That is one of the decisions that was made at the legislative level to basically require higher density even where the roads are substandard by today's standards.
But how does that work when the fire department reviews an SB9 project and they say, well, your street needs to be widened in order for us to be okay with this? I guess that happens at the building permit review stage. Is that right?
But they have to do that all the time, proving anything up in Christmas Tree Hill, for example. They have to accept that that's the existing road and they have to do their best. I think the fire chief spoke to this when we were talking about the 800 Corte Madera project, that if they had to, they could make do with the existing driveway.
Got it. Okay, I just have a project now where the fire department is requiring a widening of the street, and we're just trying to figure out the timing of that, when that needs to happen relative to the whole process to getting to the new units being permitted.
Well, if it's in the building code, they might be able to require it. We can't require it as part of our regulations.
I see, the planning department can't.
I would have to look up what the building implications are.
Got it. Okay, thank you.
Okay, so anything else before we open this up for public comment from anybody? Okay, staff. Okay,
We got this lengthy statement, and has the staff had any time to look through this and figure out whether we could do any of this or not?
We have reviewed this, and actually most of the items listed here are existing ordinance currently already does require. So we do require affidavits, and we require that a lot can't be split more than one time using SB9. So we did look at this, and the majority of items in this letter are already required under our existing regulations, and no changes are proposed in the future.
Say that the ones that I've only had a chance to skim it, but the ones that I saw that we haven't already incorporated into the ordinance are ones that would conflict with state law, so we cannot include them.
Okay, I guess I'm impressed with the research that went into this. I just don't know how or why or if we can do any of this or the implications. Would that be a reason to come back for another meeting or on?
If you like, but if you like, I could, if the commission wishes, I could go through and do a presentation on why some of these don't work and where others are already present in the ordinance. But I think Martha is correct that this has really already been addressed, except to the extent that we can.
so it's clear that in the staff report, many of those things are already a part of the ordinance. So it's in what they produced, and so the comments are based on assumptions that are not a part of the proposal here. So, okay. Good enough. All right, we're going to move on then. Ready? Okay. Valerie, you had your hand on the microphone there.
I just have small clarification, that the questions and clarifications, but they're more related to the text, not necessarily to the explanation. So I think we can address them in the comment
All right,
section.
thank you. For those of you who have been ultra patient here, if you want to make a comment at this point, you can step up to the microphone for 3 minutes. If you're online, raise your hand, please. And we'll take commentary on this proposed motion to the town council. Anybody wanting to make any statements, please step up. Yes.
My name's Corinne Grant, and I live at 1161 Meadow Crest. So mine is one of the approved lot splits. There's a lot to say in 3 minutes, but I first want to remind everybody why we have SB 9 and now subsequent SB 450. We need housing in California that requires infill, which little towns like ours have not allowed. 450 came about because people still weren't following it. And I want to remind you, you're out of compliance for almost a year. So I don't know why you get to vote on coming into compliance. I was just wondering that as I was listening to all this. You're out of compliance. You don't really have a choice. My experience has been horrendous. It took me 3.5 years and $50,000 to split my lot. So it's not a streamlined, affordable process. There's a lot of improvements that would have made it easier, but the town has not provided them. I needed a list of how to be in compliance. This is how you do a lot split, 1 through 10. Apparently, the town doesn't have that. Even though they told me lot splits are lot splits are lot splits, the way you do it has a clear guideline. We had wanted to age in place. I'm 68, my husband's 72. We thought this might be a possibility that we could build ourselves on our property, a 1,200 square foot house, and either rent out our main house, which all our children have moved out of, or we could even do a duplex and live on one side. Because the cost was so much, what I spent just on the town fee tripled the original estimate. We are just selling the lot, and somebody will build a $5 million house on it, which was not the intent of the law to infill with mansions. But that's what we're doing. We could be dead before we would get something built on the property if it took 3.5 years to split it. So I just, I don't think the spirit of the law has been followed, which was to streamline and make affordable splitting your lot, perhaps building on it. I know we live in Marin, and the estimates are $1,000 a square foot to perhaps build a house, which makes most of these things unaffordable anyway. So we're kind of fooling ourselves about what kind of housings we might get on these lot splits. I don't know why you feel you have to give courtesy notices to neighbors. It's not required. You're just doing a lot of stuff that isn't the spirit of the law, I feel.
Thank you, Corinne. Who would be next, please? Anyone? All right, I don't see anyone standing up. Oh, we have a taker here. All right.
Good evening. Lucinda Smith. I live Corte Madera for so long. Okay. My name's Lucinda Smith, and I've been a resident of Corte Madera for 54 years. I understand some of the requirements for the splitting of lots per SB 9. But I also then want to understand if once a split is approved, and then the lot, like this lady said, would be able to be sold, can that new buyer split the lot again? That's one question. I also wanted to understand, and maybe I missed it as it was being presented in the slides, about hillside applications, because I think they're pretty unique. Flood zone has their unique requirements and issues, but the hillsides have quite a few. I live on one. And then I wanted to find out a little bit more about the widening of the streets. Our streets are very narrow, especially up the top of the hill here. And I think that adding additional traffic on them is very precarious. I just talked to the police today about trying to modify or somehow mitigate the speed with which people go on our little narrow street. It's posted, but not adhered to. And so when you get additional people that are traveling on these narrow roads, it becomes a matter of safety. I also look to wonder about the notification process. I think that neighbors further than the 300 feet should be able to be notified. It's not fair if you live just beyond the 300 square feet and you get no notification of what's going on, so you can't know what's happening in your very backyard, so to speak. I think that it should be expanded. I don't have a recommendation to tell what it should be, but it's got to be more than the 300 feet that it is now. And I further think that we have a beautiful little town. We want to retain it. This lot splitting, I don't know how it can do much to help with the housing crisis, because the people, you can't make a lot, as the lady was showing you what happens. It's too expensive to build. It's not affordable.
Thank you, Lucinda.
Time.
All right, anyone else in the room? All right, seeing none, I'll ask Clara if there's anybody online with their hands up.
No hands raised online.
Okay. So we're going to say that that closes out public comment section for this item. So we're going to bring it back to the dais here and see if there's any further clarifications like Valerie has that you would like to ask staff about some verbiage.
Yes. All right. So just very shortly, there is on page 26, there are just kind of description on the provisions for the access and fire suppression standards. And then on page 32, you also have them, and they all seem to be under the 2-unit development. So I wonder if it's just a redundancy, or they could be somehow consolidated into one.
So those standards are included in both the provisions related to a lot split and also for a 2-unit development. And as we think it's best that they be in both sections, just because someone could come in for one application and not the other. So that's why they're included in both.
Understood. And then just a tiny clarification, just for my knowledge as well. When you're referring to the government code section 66589.5, shouldn't it be the 65589.5 for the Housing Accountability Act, or
Which page are you on?
32 under the D government code section?
Are you talking about the fire department standard in section D, or which?
Yes, there is so when it says this subsection provides standards to ensure fire department access to new units established under the government code section 66589.5. I just wonder if it should be 65589.5, because I couldn't find the reference to that one.
There are more questions we can come back to.
Yeah, you don't have to solve this now. This is just for, because I couldn't find the reference for that one. Anyway, and then the other on page 33, and just a little clarification, because where it says that this section replaces the town's procedures for reviewing discretionary applications. So since SB9 projects are non-discretionary, it would be nice just to have a quick clarification, maybe in parentheses, to say that SB9 projects are non-discretionary, therefore the town procedures will be replaced by these new ordinance.
You're talking about C, compliance review, item 2?
It's an A on page 33 at the end of the sentence. This section replaces the town's procedures for reviewing discretionary applications. I think it's 33 in red, and that's page 17 in the in attachment 1. I don't know if you're in attachment 1, Peter. In exhibit A,
Oh, I see. Okay, applicability there. The
Yes,
section
yes.
replaces the town's procedures for with respect to such projects. Okay, Martha.
That's from the current ordinance. So if the commission felt that language was unclear, then we could revise it. So if there's any suggestions on text, we can, that could be part of a motion, or you could ask staff to clarify it.
I see. Okay, yeah. I have no more notes.
Okay. While you guys are talking, Dan, did you have any other things you want to?
One question. Page 13. The fifth whereas down, I don't know what that means. Where it says, whereas the proposed code amendments are intended to implement Senate Bill, et cetera. I'm sorry, I didn't hear you. Okay. On page 13, whereas the proposed code amendments are intended to implement Senate Bill 450 and are not considered projects under Division 13, commencing with Section 21,000 of the Public Resources Code as provided in government code sections, et cetera. Yeah. I don't know what that means.
So they are not considered a project. That there are certain sections that deal with whether or not something is a project under CEQA. And under both the SB 9 section regarding 2-unit developments and the reference section on gosh, I forget where that lives, but these simply provide that this ordinance, because it's implementing SB 9, is not a project under CEQA. And that language is in the statute.
Okay, thank you.
Okay. Before I move over to my left, Martha, would you care to comment on the fact that lot splits second time, what the stat is per one of the commenters' questions? It's in the report that the lots cannot be split a second time.
The lots cannot be split a second time. You cannot have a sequential lot split.
Right. Okay.
Is there a period of time?
There is not a period of time, indefinitely, forever. And there is a requirement for a deed restriction. I believe that's something that's included.
Okay. So I'm going to go back over here to Margaret and see if you have any further things you want clarified from staff after hearing public comment and having more time to think. Okay. All right. Thank you. Over to you, Andrew.
Nothing further.
Okay. So what I hear is that we've got a couple of possible ministerial comments for verbiage that you put forth. Staff has taken note of those things. Otherwise, I'm going to start the process over again here and say, have you each of you say what you'd like to do with this or how you feel about it, or would you be in support of a motion to move this on to town council with any additions? Where you stand? So I'll start with you, Valerie.
I have no objections to, to make it compliant with all of the amendments and changes. There is one clarification that I wanted to ask from the letter that we have received in regards to it seems like the suggestions that were put together in this letter, those are more of the objective standards rather than the ordinance language. So I wonder if there will be a separate session on when we're going to be reviewing the objective standards and whether any suggestions, as we previously discussed, that perhaps some of them already included in the ordinance and some of them are not meeting. Would be nice to understand which ones are not meeting since other towns have incorporated them. But is it even a time right now to talk about any of these, considering that these are more of objective standards suggestions rather than the actual ordinance compliance? Correct. Yes.
So for instance, under item number 1, The town currently requires the first three bullet points. The first bullet point that we tie lot splits to real building plans. We would need to investigate if that is consistent with state law, and I think that it's not uncommon for someone to submit an SB9 lot split and not develop the property themselves. So I think a change like that would have unintended consequences. On the next page, it is required that projects comply with Marin fire standards. We don't do deed restrictions because the units aren't required to be affordable, but you cannot do short-term rentals, and that's something that is included in a agreement that is recorded with the county. And the property owners also required to sign an affidavit as well. It is only for on the bottom of page 3, it is only residential only uses that are allowed on any uses. So I would say most of these currently are required. And then there may be a few things that are not, that would require research if it was even consistent with state law. And some of these may have, unintended consequences as well. So if Commission likes, we could provide a point by point.
Okay, yes, thank you. I think that's super helpful, Martha. Thank you. So I have no objections to vote yes tonight.
Okay, thank you. Dan?
First of all, I want to compliment you on the author of this. It was very complex, and appreciate your effort. I really support the amendment to this that came in that Anne referred to relative to the definition of street. I think that's really important, and so if I vote for this, I'd like to have that be part of it. And I just for the record, nothing we can do about it, but just for the record, the statement by the legislature that no environmental or other natural things can be considered in denying this application. And I think, thank you. And I think that, while you've included the general plan statements about the need for housing, I just want the record to show, we can't put that in here, that there's things in the general plan relative to steep slopes and vegetation and a lot of environmental things that we can consider. So I just want that in the record.
Good. Okay. Thank you. Over to you, Margaret, now.
So just to be clear, there's no way that we can tie a lot split to a development within a certain amount of time.
No. That's
Okay.
not contemplated by the statute, and adding on requirements, I think would not stand.
We can't do that at all. Okay. I guess, I mean, I support the idea that we have to come into compliance. I don't think there's any question about that. And I like the definitions. I'm a little, I just don't know. Anne had mentioned that the town was waiting for a letter of clarification from the legislature.
I would put it a little differently. The town wrote to our legislators, raising the ambiguity about one issue.
Okay.
And we haven't heard back from our legislator's office. And until we get some kind of response, we may need to press them for more of a response. I would prefer not to discuss it in public.
So would that affect us needing to wait or,
No, we can go forward. We know that these are required.
okay.
We already know that.
I guess I would just, I think we ought to adopt this as best we can and send it on to the town council.
Okay, thank you. Andrew, your thoughts on that?
Yeah, I'm supportive of uh, sending this on to town council for review. I just wanted to make a note, and maybe this isn't the right time to have this discussion, but I'm sensitive to what the woman from, sorry, I don't remember your name, from Meadow Crest had to say about her experience with the process, because I'm in favor of these lot splits. I think it is a good way to create more housing, not necessarily a plethora of new housing, but I think any new housing helps. So I'm sensitive to the difficulties and the expense of going through the process. And I think if there's any way to create a document such as she suggested, where it's kind of laid out the sequence of events, and it's complicated, and even getting into who one might consult to get through the process, what professionals might be helpful for each of those steps. I think that would generally be helpful to the public who are contemplating doing these.
Okay, no, I think that's a good career move. Just kidding. It's very possible. Just like there are ADU people out there, there should be somebody doing lot splits for people. But there is.
He's
Oh,
expensive.
expensive. Okay. So goes without saying. So I believe that staff has put together a really pinpoint evaluation of the things that need to be updated to come into compliance with the state law. It's not significant. We've had something on the books since 2022, and here we are getting the language cleaned up. And I think that Martha and staff have put this together with explicit attention to every little detail that they can. So I really commend staff for doing this as usual. So given that I'm in support of this as well, I would ask for a motion to adopt this addendum. The motion sent out this afternoon for clarification, that would be the subject of a motion. Right?
Yes, so to clarify, you're recommending that the revised draft that was provided today be what you're interested in moving forward to the town council with an addition of stating that Commissioner Kenny's comments at the record show that there are things in the general plan that are not allowed to be considered in reviewing these applications. And then Valerie, did you have that recommendation to?
Yes, to the current ordinance to add the clarification on page 33 to explain the discretionary would be non-discretionary under the SB 9 lots. Projects.
And just for the record, that's to section 1831A060 little
Correct.
a.
All right, so that clarifies everything that everybody wants in there at the moment.
Yes, yes,
Okay.
and just to check the numbers.
Yeah, so make the motion, Valerie.
Fine, that reference to the government code that was incorrect.
Okay, so do we need to say that in the motion?
I would identify that as the section 66411.7. It should have been right.
6641.
Oh, okay.
Which is the government code section that provides for urban lot splits.
So 664.
11.7.
1.7. Do I need to make a motion?
Please.
Where is that one? All right.
It's this new one.
Oh, thank you. All right, I move the motion to approve an ordinance of the Town Council of the Town of Corte Madera amending section 17.20.130, 17.21.040, 18.30.015, 22.03.030, and chapter 18.31 A, and adding sections 18.24.115 to the Corte Madera Municipal Code to comply with Senate Bill 450 and for clarification. With the clarification on section 18.31A.060 to change, to clarify further the word discretionary, in parentheses to place that it is going to change to SB9 projects that are non-discretionary. And in section 18.31A.050 to correct the government code section from 66589.5 to code section 66. I got the most numbers one today. 666. Which one is next? 6585.82.21. All right. With the correction in section 18.31A.050 to correct the government code section from 66589.5 to a 65852.21.
All right. Then we need a second?
Second.
Okay, Dan second, so we can take a roll call.
Commissioner Bandel, Commissioner Rogers,
Yes.
Commissioner Bushwhaler,
Yes.
Vice Chair Kenny,
Yes.
and Chair Chase.
Yes.
A motion passes, and this will be moved forward to the Town Council.
Thank you very much. All right. So at this point in the meeting, we move on to other elements of our typical agenda. You're all welcome to stay for that exciting part, but I don't think you really want to be here for that. So we'll let the room clear. We'll just sort of, I'm going to ask if there's any commissioners with any reports tonight, because I don't have any. Okay, Mr. Canny.
This is a report on the Corte Madera Town Council meeting of Tuesday, December 2nd. And the council reorganized, and we have new mayor and vice mayor. So the main discussion item was relative to a fire protection fee to make sure that as the town grows housing, that we have the ability to have the funds for the fire department to provide staff and equipment necessary. So this fee applies to new housing, new multifamily housing. There's a lot of discussion about how the fee compared to other towns and whether there should be a staff recommended 50% reduction for affordable units. It's been continued because the council asked for some additional information relatively what the actual impact would be to a developer with this fee. So that's been continued. Then there was a second business item was approving the Public Works Department to move forward with replacing one of the fields in Town Park, main soccer field used by clubs. And they approved those funds for that project, which will go forward I think this spring.
Okay.
That's it.
That was a short meeting.
It was. We were out by a little after 8 o'clock.
That's remarkable. But that fee thing is continued.
Yes.
And I don't know if Amy wants to contribute anything on that, because it's now planning staff to comment on stuff.
Yes, thank you, Chair Chase. Sorry I'm not there tonight. I've got a cold, so I'm trying not to infect everyone. But the Commissioner Kenny talked, or Vice Chair Kenny talked about the fire fee. So that is through Central Marin Fire Authority, and they've asked Corte Madera and Larkspur to consider this new impact fee. And it will be on all, excuse me, on all residential, not just multifamily. And excuse me, and it will be, there's an urgency ordinance in place now to implement the fees before that ordinance actually takes place. And so that was adopted on November 18th. And at this last meeting, they introduced the permanent ordinance, and the second reading will be at the next meeting on December 16th. So they did ask for some additional clarification and information, so that will be provided on the 16th.
Okay.
So, yeah, if there's any questions on that one, I just one other thing to note.
A continuing story. Yeah. So does planning staff have anything else they want to tell us about?
The only other thing that I have is just to note that the December 23rd meeting, we do plan to cancel that. So the next meeting will be January 13th.
Okay. There was looking back at the notes, there was another project on the agenda for tonight. I guess that vanished. Will that come back in January?
They are making some changes to their project before they come to you for a formal hearing, so we anticipate that to be January.
So there will be agenda items then that first meeting in January.
Maybe a little too early to say, but we think so. Yes.
All right. I need to say that when I look at the calendar, let's see, the 27th of January, I am scheduled to be out of country. So anyway, somebody will take over, Mr. Kenny, if there's a meeting on that date. Beyond that, any other items that staff wants? Go ahead.
No, go ahead.
Any other items that staff wants to tell us about tentatively or not? I think that's really end of it, right? Nothing else. Okay. So then we move on to meeting minutes. So we have two sets of meeting minutes here to review and get off the table. First one is October 28th, 2025. We were all here. I was remote. But anybody have any comments on that meeting?
I do have an addition I'd like to suggest. And if we look on page 3, the paragraph, fifth paragraph down, I think Commissioner Kenny stated that he'd like to possibly save 5 redwood trees, etc. I think I also referred to trees at the corner of Warburn Drive and the 101 southbound off-ramp, which also could potentially be saved. They're not being disturbed by parking or building sites. And I think there are also some additional trees that are not where building sites are, that are not in parking, that also could be saved, that they're significant trees. And they may need some trimming and some fertilizer, but they're in good health. So
was that in the meeting? Was that something that got said?
Yes.
It was, okay. So
Yes.
then that should go in there.
Additional context about the trees in addition to those 5 redwoods.
yes, please.
Okay. Does that complete those additions you want to make?
Yep.
All right. Thank you. All right. So we can vote to approve those meeting minutes for October 28th. Does everybody say aye?
Aye.
Okay. Then we can move to November 19th. Meeting minutes. Are there any additions to these notes from anyone? All right, seeing none. We'll vote on these by voice vote now. Guys, all ready? Say aye.
Aye.
Aye. Okay, we have 2 sets of meeting minutes approved for the record. All right. With that said, Merry Christmas. Let's adjourn this meeting. Thank you very much. Bye, Amy.